How are you?
How can I help you?
I'm here to serve a notice of liability for a court today.
What?
I'm here to serve a notice of liability.
Okay.
You can also give me a copy of this as well.
Hi.
Hi, how are you?
Do you have a case with us?
Yes, I do.
Oh, okay. Okay, so do you have the, are you submitting paperwork for Indiana?
No, no.
Oh, okay, it says Indiana.
It does?
Okay. Can we get your date of birth so that we know what file to put this with? And your name, please?
Excuse me?
Your name?
Cameron Wilson.
All right, there we go. Did you see if you pled not guilty, or do you have an upcoming trial?
Yeah, but I don't plea.
Oh, I got you. So we did a no contest for you then, probably the good. I mean, not guilty. Okay. Okay. So we'll put this with the file then.
I need a copy, please.
Okay. Brought a copy, yes?
No.
So here's your copy, and then you're all checked in.
Thank you.
Okay, all rise. The court is now in session. The Honorable Judge Court is now presiding.
All right, well, about the parties, come on up. So Mr. Wilson over here, please. And then Chief Miller over here. Good afternoon. On this case, so I'll hear argument on that if there is any. Did you get a copy of it? No. Did you serve your pleading on the other side?
I don't plea.
Okay. Well, then I'm not going to consider it because you didn't give it to him. That's what it requires.
Well, what's required by the court? I submitted it to the court. It's not my responsibility to submit anything to another trooper whatsoever. I submitted it to the court for your review.
Hold on, sir. So the way it works is if you want to consider it, you got to give it to the other side.
Where is that ruling at, and where can you establish that for the record? Could you give me any kind of indication rather than just a statement?
It's the rules of
What rules?
procedure. Thank you, sir.
Okay, what rule and procedure, please?
It is in the rules, sir.
Okay, I'm not going to just go off of a statement, my honorable judge. Is there a rule and procedure that you can quote in which it is required for me to provide any kind of documentation over to the other party?
Okay. It's not my requirement to explain to you anything. So here we are. We are set for trials. Or anything?
Objection. I'm going to object to that right off the bat.
Okay.
That's on hearsay.
That is not what that means. All right. Is there anything else?
So is that a suspended objection?
The objection is overruled.
Okay, thank you. Make it note for the record that the objection has been overruled.
Sir, do you know this is not a court of record, right?
This is not a court of record?
No.
So then how can anything be done properly by the Constitution if this is not a court of record whatsoever?
Well, we will produce our written record. And then if you don't like what we do here, you could appeal it to the circuit court, is how it works. But it's not a recorded. So, is there anything else pre-trial? Clear.
Excuse me?
Is there anything else pre-trial?
Well, I think when I submitted, honestly, when I submitted the notice for abatement and demand, there was a request on there that states that you were supposed to give any kind of rebuttal in relation to the information or the motion that was submitted to you. Have you been able to rebut that or give any information?
As we have already discussed, you did not serve it on the other side, so I'm not considering. All right. Is there anything else pre-trial?
So yeah, I think before even proceeding, I need to understand what kind of codes you're speaking and quoting of, because I'm just hearing general statements without there being any kind of numbers or rulings of the procedures itself. I would just like to get further clarification for that.
Okay. If you think I made an error, you get to appeal, you get a de novo appeal at the circuit court. That's how it works.
Okay, I'm not asking for an error. I'm just wondering where what procedure is that? What code procedure in the policies and procedures states that I'm supposed to submit any documentation over to the opposing party?
Okay. I am not going to argue with you. I've asked if there's
Okay.
anything else pre-filed.
For the record, my own personal record, I'm going to state that I'm Cameron James Wilson, a living being, a creation of the Creator, standing here before this honorable court, here as pro se in my own counsel. I've appointed myself as my own attorney, and I'm ready to proceed with the administrative and procedural matters. At this time, Your Honor, may it please the court that I motion for a dismissal with prejudice for failure to state a cause of action in which relief may even be granted. As a judge of a third party, are you the judge with a third party of interest in this case as a trial of fact?
I'm sorry, are you making a motion to dismiss on what grounds, sir?
The grounds that there is no jurisdiction whatsoever.
How is there not jurisdiction?
First off, I would like to see proof of jurisdiction by this court. The burden of proof lies on the court itself, if I'm not mistaken. So where I'm going to show this at, it has been held in regards to the court's inferior jurisdiction. If the record does not show upon its face the facts necessary to give jurisdiction, they will be presumed not to have existed. This is Norman versus Cyber. Also, it is U.S. versus Will 499, U.S. 200, 216, 101, Section 471 of 66. When a judge acts where he or she does not have jurisdiction to act, the judge is in an act or acts of treason. The Supreme Court of the U.S. in 1795, inasmuch every government is an artificial person, an abstraction, and a creature of the mind only. The government can interface with artificial persons only. If you have called today a Cameron James Wilson with the number 6, I do have the deed right here of the corporate entity in which you seek to speak to. Now, I am a living and natural being. I am not a corporate fiction. I am not a person which is a corporation. As a executor and beneficiary of the actual trust itself, I am not a trustee. I am a living man. So the only actual interfacing you can do is with the actual corporate entity. And as an administrator and trustee over this account, I would advise you to set off anything and get this taken care of yourself.
Okay, your motion is denied.
On the jurisdiction aspect,
You've not given me any reason to dismiss at this time, so...
the burden of proof lies on the court to provide proof that there is jurisdiction.
I respectfully disagree. If you think I'm wrong, you can appeal, right? And maybe your case will be the case that holds that, but...
Okay. Okay, so one more thing here. A court has no jurisdiction to determine its own jurisdiction. Rescue Army versus Municipal Court of Los Angeles. Do you understand, and may I get it on the record, that you acknowledge that the Supreme Court is the supreme law of the land?
I'm not here to answer your questions, but is there a motion, sir?
The motion has been set forth, and it seems as though you are not respecting any of the motions that have been put forth.
I have not granted that. That is true. Now, maybe I'm wrong. And if I'm wrong, the way you figure that out is you appeal to the circuit court, which is a court of appeal. All right, so I am ready to proceed to trial, so I'll swear you both under penalty of, swear you ready to swear? Under penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Of course.
Okay, I'm going to take that as a yes. All right, so the state gets to present this case first.
Your Honor, my name is Pat Miller. I work for the Oregon State Police. I've been in law enforcement for over 24 years. On October 24th, 2022 at about 2:51 p.m., I was traveling northbound on Interstate 5 near milepost 266. This is a location within Marion County. I was driving a marked police car and wearing a uniform as seen today, displaying badge. During that time, I was in the C lane, or the number 3 lane, going northbound on the freeway. And I was driving a gray BMW that I saw cross over the fog at least 3 different times. I pulled up alongside it, so I switched lanes to the middle lane, pull up alongside the BMW, and I saw the driver manipulating a cell phone, texting or dialing or something using the phone. I slowed back down to get behind the BMW, and I noticed before I made the traffic stop there was no license plate on the vehicle. And I called out the description, vehicle location, and that we were attempting a traffic stop at that time. The driver of the BMW did pull to the right shoulder, and I contacted him on the passenger side. Looked again to make sure I wasn't missing like a temporary tag in the window, which I did not see. And the driver was alone in the car on the left, and he rolled down the window approximately 2-3 inches, and that was it. So it was difficult to hear him. I'm assuming it was difficult for him to hear me with the passing traffic going by and whatnot. I introduced myself to the driver, explained why I stopped him. I asked for his identification and insurance, and he told me he didn't have to provide any kind of identification on him. And he stated, and I'm going to quote this, by way of the Constitution, I don't have to provide an identification, as well as I don't have to register this car as DMV. At that time, I'm identifying the driver now just by appearance. He asked that I call a supervisor, which I did. That was going to be about a roughly 15 to 20 minute response, but we were willing, and so the supervisor wasn't around. After some...
I got an objection.
What is the nature of your objection?
Yeah, misstate evidence.
I mean, how is it misstating evidence?
Yeah, he's not providing any evidence that this is a true and accurate statement whatsoever. He's saying that he, quote, this is what I said, but there's no evidence that is being shown to the state that that is accurate and true.
Oh, well, his testimony is evidence. Now, you can give conflicting evidence if you so choose, but your objection is overruled. He is allowed to testify to his recollection of what he said.
After I had called for the supervisor, I was talking with the driver, and he eventually did actually provide a Texas driver's license, or a Texas ID card. I ran the individual's name on that, which was Cameron J. Wilson, birthday 2/5/87, from the Texas ID card, and he came back suspended in Oregon. The DMV return also showed that he was required to have an IID kit in the vehicle, which I did not see. I asked the driver, Mr. Wilson, if he had any insurance on the car, and he said he didn't, and then he wasn't required to provide any insurance on the vehicle. At that time, I issued him a citation for driving motor vehicle while using mobile device, driving while suspended or revoked, driving uninsured, and failed to install an IID in the vehicle, and failed to display license plates. At that time, he was treated, and he did so.
Is there anything further, sir?
There.
Okay. All right. You may ask questions if you have questions to the witness.
Is the witness going to be brought to the stand?
No.
Wouldn't it be proper if the witness was brought to the stand?
No, he can stay there.
Okay. No, not at this time, Your Honor.
Okay. Well, this is the time, right? So think about it. If you've got him, this is the time now.
Well, I'm just trying to figure out what probable cause you would think that you have to pull over someone who is not operating in commerce.
Is that a question?
Yeah.
My probable cause for stopping you was manipulating your cell phone while you're driving.
Okay. So nobody has the eligibility to be able to touch their cell phone while driving?
Correct.
And what would be your definition of driving? Or let's just ask, what is the definition of driving within the vehicle code?
Well, my definition of driving is driving on the freeway at any speed.
Sir, I didn't ask for your definition. I asked for the definition that's within the vehicle code or within Black Law's dictionary.
I don't have that with me.
So clearly what we have going on is a misinterpretation of the words driving. Driving by Black Law's dictionary.
If you want to do argument,
Okay.
there's a different time.
Okay, cool, not a problem.
Yeah, we gotta.
Go by the procedures, I got
Out the way
it.
to
Yep,
tell us
yep,
to
for
do it.
sure, yeah.
All right, so done with questions?
Yes.
All right.
Well, actually, no, Your Honor. May I ask one more?
Yeah.
When I advised you of all that I was reserving all rights and that I wanted an attorney present and did not want to speak any further and pled the fifth, why did you continue to ask me questions anyways?
I don't recall that comment.
You don't recall that comment. Do you have audio and video recording?
I do.
Did you submit that to the court?
No, I did not.
Okay. When can I and how can I submit that to the court for further review? For further deliberation?
Oh, well, so today's the day of trial.
Okay.
Right?
So do I need to submit that right now, and how can I submit that?
Well, I don't know, you're in charge of your own case, right? So
Mhm.
usually people ask for discovery before the case starts.
Okay.
Yeah.
Yeah?
But now's the day.
Okay, so how would I present that? Do I pull it up as an exhibit to plug in my phone for the TV for further review? How can we do that?
Do you have an exhibit right now?
I could submit an exhibit right now, yes, sir.
Okay. Well, so usually you put it on a thumb drive beforehand. Usually you coordinate with the court. And you
Most
do
definitely.
this stuff
Most definitely, yeah.
right?
Yeah,
So what I hear you doing is starting to present your own case.
yeah.
Okay? So you can, if you're done with questions, start your own case.
Okay.
Is that what you're doing?
Yeah, let's do it.
Okay.
All right, so what I want to do is I first want to start off with the understanding and give some foundational groundwork, right? It is acknowledged everywhere, including the United States Constitution, that laws passed under it or case law interpreted under it are the supreme law of the land. In other words, Supreme Court holdings and rulings apply to all 50 states, no matter where you are territorially. Am I correct in that?
Let me interrupt you for a second.
Yes, sir.
So first you give your facts, and then you do your argument at the proper time. Right?
So-
So do you have facts? to
So
provide?
the facts of the matter of the occurrence that took place, is that what you're stating?
Yeah, so usually people, and it's up to you if you want to testify or not, but usually people testify as to what happened according to their perception. Okay?
So, first off, yeah, if we're going to go through facts, I'm a free man and I operate in common law. Okay? I have a right to travel freely and unencumbered, pursuant to Shapiro versus Thompson, and that right is so basic it doesn't need even to be mentioned. So as I am traveling as a free man, not as a slave or a corporation, on the highways, I am not subject to any contractual agreements within the state. And as traveling on I-5, going north, an officer pulled up next to me and saw that I was touching my cell phone and was not holding it. In that manner, he saw that I didn't have license plates and then decided to pull me over. As we spoke further, I advised him of my rights and that I wished to reserve all of my rights, and I did not want to speak further, that I am not in a contractual agreement with the state whatsoever to have a driver's license, or do not have a contractual agreement with the state of having a driver's license whatsoever. I advised him of all of my rights. He proceeded to tell me that if I did not present it, that it would be a crime, even though no crime had been committed, nor was there probable cause for him to stop me in the first place. He went back to his vehicle and called.
Let's just, I'm a sort of put the cards on the table kind of guy.
Yeah.
And I think I told you at our main met, right? Like, I'm pretty well versed in constitutionalist theory. I don't subscribe to it. So just.
Constitution. You don't subscribe to the Constitution, sir?
Not to the theory that you put forth in your brief. I just don't, right? And I told you that, right? So just assuming that I don't. Do you have any facts or argument? Because I don't want to waste anybody's time here.
Well, I don't want to waste my time either, but I feel as though.
You're talking over me.
Oh, excuse me. Sorry. Yeah.
That's okay. So just assume that I'm not a believer in that theory. Okay? Is there anything that can help your case that doesn't depend on this constitutional?
I think I would have to. It's hard for me to figure out. You're not a believer. Your job is to uphold the Constitution, and you took an oath to uphold the Constitution.
So assume that I believe that it is constitutional for the state to require license and otherwise regulate driving on the freeway. Like, just assume that, because I do.
Justin, I would agree with you that the state does have authority to regulate drivers.
Okay. All right. And let's assume that my version of driving includes holding the car, steering wheel, and putting the gas pedal down on the freeway. Just assume that's what I believe. Okay. Now, maybe I'm wrong. Maybe it doesn't mean that at all. And if that's true, right, the way to suss that out is to go up to the Court of Appeals, and they may hold that.
Well,
Right. And but look,
yeah.
bear with me.
Yeah.
Right. Like, so we all use our time well today, and
Yeah.
realizing there is no recording. Right. So you're not building a record for anything.
I'm building my own record.
Okay, fair. But just assume that's what I believe, okay? Is there any argument that you have that's going to be relevant to help me decide in your favor?
Yes, Mr. Kidd, I really do, Honorable Judge. I think, we all know that we had forefathers that died for us, several millions of people that died for us to secure our liberties, for the pursuit of happiness and life and religion. My religion does not subscribe to having any authority over it unless there has been a trespass against another's rights whatsoever. So within my religion and the understanding of my religion is that I can travel freely upon this land at any point without the need of any authoritative figure to tell me if I can or cannot. And some of the arguments that I would like to present to you, if I may finish, would that be okay with you today? Because
let me make sure. So you're presenting a First Amendment argument. That
Most
you have
definitely.
This right to travel regardless of the statutory constraints on driving or the rules of travel.
Most definitely, because if you and I are both in agreement here, we both understand that the state is nothing more than a corporation. Am I correct?
Well, I'm not here to answer questions. I'm trying to understand what your theory is.
Okay. So my understanding from the Supreme Court is that the state is nothing but a corporation.
Yeah,
So how could a corporation have power over
I'm
a...
interested in where you're going for it, right? So do you have a case that tells me that the First Amendment regulation, the First Amendment right driving?
If you may just give me one moment, I would like to find something that I would like to address with you, please. This is going to be Robertson versus Department of Public Works, 180 Washington, 133rd, 147. Complete freedom of the highways is so old and well established, a blessing that we have forgotten the days of the robber barons and toll roads, and yet under the act like this, arbitrarily administered, the highways may be completely monopolized. If through lack of interest the people submit, then they may look to see the most sacred of liberties taken from them one by more or less rapid encroachment. Another one I would like to also mention is personal liberty or the right...
Let me pause you for a second.
Yeah.
Here's the problem. A lot of the cases in your brief, and including that case, are from other states. Right?
Supreme Court, yeah.
But not the Supreme Court of the United States.
Yeah, Supreme Court.
Of Washington, right? So the Supreme Court of Washington is going to help me here.
Okay. May I mention another one then?
Yeah.
Personal liberty or the right of enjoyment of life and liberty is one of the fundamental or natural rights which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from nor dependent on the U.S. Constitution, which may not be substituted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right to private property, and is regarded as inalienable. 16 CJS Constitutional Law, Section 202, page 987.
That's not a court case. CJS is just a compendium of other stuff. Right? Amjur is not a court case. That's how you cited Amjur quite a bit. It's not. So, I'm going to save us a little bit of time here. Right?
Well, I would like to present my further arguments. I feel as though I'm being cut off at this point. Do I have the opportunity to present more of my arguments in which I've prepared for?
It depends, right? It depends on if it's new.
Okay, great. Let's do it. So some of the definitions within the terms here in Oregon within the vehicle code is 801.590, which is vehicle. Within this code, it says means of any device in or upon by which any person. Do we understand? May I ask for the definition of person in your...
Let's assume that I believe you are a person.
Okay.
Right.
And what would give you that assumption?
Again, I'm not going to answer your questions, but I'm telling you, just for the purpose of the economy here, I'm going to find that you're a person.
Okay.
Right?
So a person by definition within Black's Law's dictionary is also a corporation.
Black's Law's dictionary is not the dictionary we use in this state.
You don't use Black Law's dictionary in this state? Not at all?
No.
Okay. So again, I'm going to use it in this for my records, which is a corporation is a person, okay? Now, a driver's license within the code, which is 801.245, is a license which may have any of the following which applies to a privilege or a grant of authority of jurisdiction to a person. I have no contractual agreements with the state whatsoever. So with there not being a contractual agreement with the state, how can the state impose that I must follow any ORSs whatsoever? That's what that would be a
Next time
question.
you have one of these cases, you should look up the police power.
Police power is also within, right at the bottom, it says infra, within constitutional limitations. So still, the police power is no argument whatsoever. And if we wanted to dive into police powers, we actually can, because I have a pretty lengthy argument for police powers. Would you like to go through that with me,
I
sir?
read it, actually, I did.
You did?
I did.
So you did review my documentation, but you
review
did
it.
not support any opinion whatsoever, even though there was a request made to the court?
Well, see, the thing is, you didn't provide it to him, so that's where it's out. But you're talking about it now.
This is very weird, because this is the first time that I've ever been presented with the court to state that I must provide documentation to the officer in order to submit it to the court. I did not submit it to him. I submitted it to you for your review.
Okay, well, then you probably haven't been through a lot of courts, but that's how it works.
No, I've been through
I'm not
quite a few.
doing that moving. Is there something else?
Again, the confusion of police power with the power of taxation usually arises in the cases where the police power has affixed a penalty to a certain... First off, where's the verified complainant? Who's the verified complainant within the state? Is there a verified complainant? Is there a verified complainant here?
This is the time for you to present your case, sir.
My case is being asked, Your Honor. Is there a verified complainant within this case?
I am not a witness for you to ask questions of. That's not how it works.
So according to the Federal Rules of Civil Procedure, Rule 1, there is only one form of action, which is a civil action, okay? There needs to be a real party of interest, not the people. There needs to be someone as far as a verified complaint. If there's no verified complaint, there is no corpus delicti either. There is no plaintiff.
We're not under the federal rules. It's not the federal rules here.
Federal rules apply to all citizens.
I don't think so.
What makes you think not?
Okay. Well, I'm going to hold that the federal rules of civil procedure don't govern here, okay? So again, if I'm wrong, and maybe you'll prove me wrong, but the way to do it is to run through the Oregon Court of Appeals.
So where is the real part? There is neither an injured party nor a trespass here. Would that be a safe assumption to make, or a matter of fact? Where's the part? Where's the cause of action in which I can have remedy?
All right, are you making a motion? I don't know what you're doing at this point.
I am trying to figure out where there is an injured party. If there is no injured party or a verified complaint, how can a charge be brought against me? A bill of attainder. Or rather, not even against me, it's rather against the corporate entity.
Okay, are you making a motion?
Motion for dismissal.
Okay, that motion's denied.
On what grounds?
We don't run under the federal rules of civil procedure. It's the one rules.
So there's no plaintiff. This is an adversarial proceeding. And as it is alleged, defendant's limited comprehension, adversarial proceedings require real adversaries. This is true?
Is there a motion?
A motion to dismiss on the fact that there's no plaintiff whatsoever.
That motion is denied.
On what grounds?
So the criminal case is the state of Oregon versus you.
So what crime has been committed?
It's violations. Sorry. You have the complaint right here.
So a violation is not a crime.
Sir, I'm not going to go in circles with you. The motion's denied.
You just stated that I have crimes held against me, but violations are not a crime.
Maybe the court of appeals will be real interested in that. I don't know. But I've made my ruling.
So there is no corpus delicti. Crime is a breach of laws or governing authority. While this alleged offense or violation was a violation of the law, it was not a crime. As my limited comprehension permits, these matters are criminal, notwithstanding proof of the corpus delicti is required in all criminal matters. If we were to proceed and you were not to motion for a grant of dismissal, this would fall under USC Title 18, Section 242 for deprivation of rights under the color of law, as well as 241, which would also be conspiracy against rights.
Is there a motion?
Yeah, motion for dismissal for conspiracy and deprivation of rights under the color of law. And no corpus delicti.
That motion is denied.
Where's the corpus delicti?
Is there a motion?
That was the same motion that you just didn't answer. So where's the corpus delicti?
Okay. If there's no motion, you should probably move on.
Okay, the motion would be for dismissal for no corpus delicti.
The motion is denied.
On what grounds?
It's not even a thing.
Excuse me?
It's not even a thing.
Okay, so where's the corpus delicti?
If I'm wrong, you should take it up with the Court of Appeals. They might find that you're...
Honorable Justice Kidd, why are you not giving any opinions whatsoever and you just keep saying deny with no grounds? You're just if you keep saying that I'm running circles, but you are not giving any grounds whatsoever. Is this a court of law? What is this? I'm very confused on this proceedings.
Is there anything else? I mean, I think that your time is valuable, right? And so I'd like you to use it in a way that benefits you. Is there anything else?
Since I have relied on previous decisions of the U.S. Supreme Court in constitutional defenses, I have a perfect defense for willfulness. I am immune to the prosecution, therefore prosecution counsel does not have a cause of action for which relief can be granted. I motion for dismissal with prejudice for failure to state a cause of action in which relief may be granted, and I'd kind of like to collect my cost and fees and damages for having to defend this frivolous case.
Okay. There's not a mens rea requirement for traffic violations. There's just not. So that motion is denied.
Well, Honor, I'd like to know how relief can be obtained here, or remedy can be obtained, because with everything
Well,
I've
if you
seen...
think I'm wrong, you do have a remedy. You appeal it to the circuit court. That's what you should do.
And what is...
Maybe I'm really wrong. I don't know. Maybe you're totally right. But they're smart studies downtown will correct me if I'm wrong.
Yeah, there are some very smart people downtown as well as attorney generals that will be involved in this, and this is going to be on court of record. So,
Okay.
do you seek to continuously violate my constitutional rights by depriving me of my rights, which has been granted by the... Well, it hasn't been granted; they're unalienable, but which has been recognized by Supreme Court law?
Is there anything else?
No, there's nothing else.
Oh, is there any rebuttal?
No, Your Honor.
Okay. So in this matter, the standard of proof is the preponderance of the evidence standard. I do find that the state has met its burden on all counts. So we find that you're guilty on all counts.
I object. Lack of evidence.
Okay. If you disagree with me, that's fine. The way to do that, like within the actual bounds of the law, is you appeal to the circuit court.
I objected. Is it sustained or granted?
It's not a continuing objection.
You stated that the state has provided sufficient evidence, and I objected to the lack of evidence.
Yeah, no, but I did find there was evidence, so that's fine. If you don't
What evidence?
agree with me, then what you do
A
is
testimony?
you appeal it to the circuit court. That's
A
fine.
testimony is what you consider?
Yeah,
as-
I did credit
Great.
testimony.
This is going to be great.
So, but seriously, that's how you do it. If I'm wrong, so everyone wants to correct my head.
Do you believe that I'm a natural person? Or do you believe I'm here because I am a natural living being? I'm not here representing the corporate fiction entity in which you are seeking.
Yeah, and as I told you at arraignment, that's I'm just not a believer in that shell corporation myth that people sell.
It's not a
People
myth.
sell. Okay, well, look, maybe I'm wrong. And maybe the people downtown will correct my error. That's how it works. But I'm not going to find that. So, we're going to move now to the sentencing phase. The presumptive fines in this matter are $265 with a maximum fine of $1,000, $440 with a maximum fine of $2,000, $265 with a maximum fine of $1,000, $440 with a maximum fine of $2,000, and $115 with a maximum fine of $250. So the actual fine again could be higher, lower, or stay the same, so long as it does not exceed the maximum fine. I'm first going to ask the state if they have an opinion on what I should do on sentencing, and then I will ask you. Do you have an opinion, sir?
No, Your Honor.
Okay. Do you have an opinion, sir?
I do have an opinion. My opinion is that several of my ancestors died to secure our freedom, and to disrespect our freedom in a manner in such which as I've seen today is pretty outstanding. It's pretty upset to see that the Constitution is being trampled on, and treason has been brought forth in this court today, and the deprivation of my rights under the color of law, which is not true law, has been upheld by you. And it's very disappointing because I really thought today that you would hear some arguments and understand what is true and what is real, and give a great opinion in which we could have a great deliberation on. And it's just very sad to see that this is the state of our country. It's very unfortunate. I just feel really bad about the state of where we are in a country where a corporation thinks it has more power than the living man. Because my understanding is that it's God, man, government. And as public servants, I've given you every eligibility to go ahead and settle these matters in a trustee capacity. And I would seek that you settle these matters as a trustee, as I am the beneficiary and executive in these cases and manners. So, or at least you approaching the corporate entity, should I say.
All right, sir. So in this matter, I do find that the statutory fines are the appropriate fines. 265, 440, 265, 440, and $115. All right. So, it is true that you and I have different interpretations of the law here. Could be that you're right. Right? The way to see if you're right is to go to the circuit court, appeal there, and then go through the court of appeals. Could be that this is the case that writes that law.
I think I just have a really misunderstanding on, you should know this, is that there has to be a contractual agreement. I don't have a driver's license in this state. So how can any statutes be brought against me? How could I be stated that a license is suspended or that I need an IIED if I am not in a commercial capacity? The vehicle code states clearly everything is commercial. I don't have a driver's license with the state.
We're just going to agree to disagree on that, right? And I've issued my judgment, but it might be that I'm wrong.
Yeah, there's no doubt. I've studied the vehicle code.
And you should definitely appeal, right? That's how you do it.
I just don't understand how you could be up here administering these manners and not know.
Okay. All right. That's fine. All right, so I have made my judgment. So I need to do within 30 days, or you need to get out and or you need to appeal.
Oh, it's getting appealed. There's no doubt about it.
All right.
The Attorney General's getting contacted today. Horrible. So just for reference, what ended up happening after this is I left and I never heard from them again. There's never been anybody sending me anything in the mail to pay anything. And if they did, who's going to pay them? Who's going to tell me or try to enforce that I must pay them, right? Where does it go? It doesn't go to no collection agency. It must be sitting somewhere deep in a file somewhere at their courthouse because they ain't getting no money up out of me because they can't enforce it because there's no contractual agreement. So while it sounds good there in the court, ain't much they can do after this. So I hope y'all enjoyed this one. Again, this was my very, very first one. So, yeah. All right. Y'all stay tuned. There's more to come.